argument using all of the Geisler factors, which are not factually laden, which are not determinative on credibility determinations, which is the only reason you'd go past a motion to strike to make to go further in the trial.
Is this the first chance the parties have had to, and I agree with you about the evidence, it doesn't have to be evidence produced, but at least input, argument, presentation of the appropriate material under the factors. Isn't this the first chance the parties have had to address specifically the Geisler factors and what a court should take into account?
Well, if you look at the lower court briefs, I believe you would find that there is not a Geisler construct, Section A, Section B, Section C, the way this court often does. But the Geisler factors are in play. The text of the Constitution, the history, its purpose, the plaintiffs surely had an opportunity to demonstrate why they have a cognizable claim under our state constitution. I think it's fair to say they're able to put forth all of those arguments. And they can do that here. There's really nothing in the trial court. If the trial court were to conduct a Geisler analysis, this court ultimately determines what Article 8, Section 1 means, whether the state prevails or the plaintiffs prevail. The only reason to undertake that analysis further in the trial court is if there were some sort of disputed facts. The light was red, the light was green. That's not happening in Geisler analysis. The sort of factors, historical or otherwise, and evidence that the court may discuss in its Geisler cases are not credibility determinations to be made.
Dioria, going back to an earlier dialogue about your point essentially is that as long as it's equal, it doesn't matter how bad it is or how good it is, because there's no qualitative component. Is that correct?
It's not that it doesn't matter, Your Honor. It's nothing that a court can measure in and of itself. It matters. It should matter to the executive branch and to the legislative branch.
So you would eliminate any discussion about reasonable from the analysis at all?
I would. And the plaintiff's reference to reasonableness analysis, which does go on in the context of criminal cases, mostly, unless they're contractual cases where common law makes up determinations of whether an amount of time, an amount of time in a breach is reasonable or whatever. Reasonableness comes up in the probable cause context, comes up in other, search warrant type situations.
Expressly, but what you're suggesting is that it's not even there implicitly. And when do we read anything? When do we read reasonableness out of things, particularly constitutional rights? I mean, even the dissent in Horton, I think Justice Loisel talks about there's always got to be at least a reasonable component.
Well, he didn't say that. He said there's no claim that there's no meaningful education being provided here.
Well,
he didn't say that.
I'm reading from the trial court's opinion in which he says, quoting Justice Loisel, "I will concede that when the Constitution says free education, it must be interpreted in a reasonable way. A town may not herd children in an open field to hear lectures by illiterates." Right.
In that case, they wouldn't be providing schools, getting back to Justice Palmer's question. That would be a justiciable argument. But Justice Loisel said, and not that I hang my hat on Justice Loisel's dissent.
I'm just troubled by the whole notion of I understand the qualitative suggests it's on the high side and the reasonableness is on the low side, and I'm hearing you to be saying it's just not a factor.
It's not a factor to this court. It's not a factor in a cognizable claim. Adding a reasonableness test that a court could then measure, if it were ever equipped to do so, in a vacuum by itself, not as a comparator, but just by itself, is essentially to recognize an unenumerated right, an unenumerated qualified right. So, Your Honor, if I may rephrase your question, I believe you're saying, isn't it implicit? And your court's cases say, no, we won't read implicit constitutional rights. That is more. That is more almost,
But the flip side is to say a constitutional right that essentially does not have a reasonableness component.
as a substantive matter, I would concede it. Yes, that as a comparator, and this shouldn't frighten the court, because the court has an equality check, an equality role to play.
So as long as it's equally bad, it's okay.
Your Honor,
I just want to make sure I understand you. I don't mean to be
if it's
argumentative.
equally bad, the democratic process should and will correct that. There's under no reading of these plaintiffs' complaint can it be said that every child in Connecticut is receiving an inadequate education. Much to the contrary, their complaint is full of the fact that kids in different areas of the state do not receive the same educational opportunities. Those are cognizable claims. Those are justiciable claims.
If it's equally bad, then there's not much to the fundamental right. And the equally bad should be subject to review.
The democratic process, the quality of the education is committed to the democratic process. That's what appropriate legislation means. So, appropriate legislation does not mean we'll determine whether you've done the appropriate thing. In fact, the court in Rose, which is quite literally Rose, the mother of all finance cases and quality cases, it's cited everywhere. Rose itself said, this is a statute, this is a constitutional provision that says General Assembly shall, by appropriate legislation, provide for an efficient system of common schools throughout the state. The court said legislation is only inappropriate if it conflicts with some other constitutional provisions of equal dignity. That's the point, Justice Zarella, you were getting at, that CCJEF is different because it conflicted with the segregation clause. Horton is different because it conflicted with the Equal Protection Clause. In Rose, the determination with some language to go by that the court construed, they said it does not pass the efficiency clause. But to just say appropriate legislation gives the court license to say you should be doing more, you should be doing something else, that's not what appropriate legislation means. Appropriate does not modify education.
It seems to me a moment ago that you came close to conceding that there is some kind of minimal standard. You reacted, well, that would not be a school. I mean, obviously, I think we would all, as a matter of common sense, agree. We hope we would recognize when it's a school and when it's not. But doesn't that suggest that there is a qualitative standard, albeit minimal, for what satisfies that, what constitutes a public school? And therefore, to satisfy this provision, there is a qualitative standard of some sort built in. And we can quarrel about the words, but there has to be something that distinguishes it from a non-school.
Yeah, that is possible, Your Honor. That is possible. To determine what is a school, I have to say, would be justiciable. Whether that connotes a minimal standard, given that there's no question under these plaintiffs' complaint that they're going to schools, but whether they're adequate schools, whether they're of high quality, I just believe that
there's a lot in between, and I think
there is a lot.
You would probably agree with me that it's not just bricks and mortar, so to speak, and books, that there are intangible qualities to a school. And it seems to me that we're right into implied quality necessarily in the word by providing a school.
Right. It doesn't go very far. I don't believe
it's a little way.
I don't believe we can put our finger on it, Your Honor, to say what is a school, and then there are no teachers in it, for instance. I agree with that, but that's not what we're talking about here. We're talking about, if you take the plaintiff's complaint as it's alleged, as we must, how many computers are in a school,
well,
what the quality of training of
what about having the elements? You've got a building, you've got a teacher, you've got some books, and nobody does anything all day long.
Right. Right.
Do we have a school or do we not have a school?